Hello and welcome to ThePrint. I am Ruchi Bhattar, and in a historic first, the Supreme Court has implemented the passive euthanasia under judicial supervision in India, a decision that again brings the country's complex debate on the right to die with dignity into sharp focus. By allowing the plea of withdrawal of life support for a 32-year-old man who has remained in an irreversible permanent vegetative state for the past 13 years after falling from a building, the court has implemented the framework for passive euthanasia for the very first time. Today, I'm joined by two eminent members from the case. Rituparna Padhy, who was part of the team assisting the advocate on behalf of Harish Rana's parents in presenting arguments before the court and ensuring that the wishes of the parents were responsibly presented before the court. Previously, her team at Vidhi had also assisted the Supreme Court in the 2023 Common Cause matter, where the court revised the original guidelines for withdrawal of life sustaining treatment. We are also joined by Advocate Shivika Mehra, part of the additional Solicitor General Aishwarya Bhatti's team, who represented the central government in the Supreme Court. Thank you so much, both of you, for taking out the time and joining us. My first question to you, Rituparna. This case involved a man who had been in a vegetative state for 13 years. So, what exactly, please tell us the family side, what exactly compelled the family to approach the court before the court for passive euthanasia, and also take us through the Delhi High Court journey as well?
Got it. I think just to provide some further context on how Vidhi was involved in this is that we were part of the legal team for Harish Rana and his family, his parents and his siblings, and we were a part of this journey from the beginning when they had reached out, and in their initial request and the discussions that we had concerned talking about Harish's best interests, about his dignity, about the concerns that they are facing due to, the provision of clinically assisted nutrition and hydration, that is CNH, and the court also refers to it through feeding tube, and they had simply approached us requesting for discussions and options on ensuring that Harish leads a dignified life, and he does not have to undergo any further indignity. And then we, of course, went into the discussion of the 2018 judgment where the Supreme Court had initially approved the withdrawal or withholding of life sustaining treatment following Aruna Shanbag's judgment in 2011. And then later in 2023, of course, when the court revised the 2018 guidelines. And it was based on that the family first approached the court requesting for.
When was the first time the family approached the court for the first time? Could you tell us?
This happened in 2024 when they initially approached the Delhi High Court, and the request was for the establishment of a primary medical board, because that is the first part of the process that has been laid down by the Supreme Court in the Common Cause judgment. At that time, the High Court rejected this request on the erroneous assumption that the artificial nutrition and hydration that is provided is not medical treatment, and that this is a case of active euthanasia or euthanasia in general, and therefore they rejected the plea on those grounds. Then we went to the Supreme Court. The Supreme Court heard our matter, and of course, at that time there were extensive discussions on whether withdrawal is in the best interest, whether the concern is actually that sufficient treatment is not being provided. So initial discussions led to the conclusion that the state will reimburse the funds, the treatment that Harish is going through. And this was reached at after shared decision making with the family members. However, Harish's condition continued to worsen, and based on, of course, further discussions over the course of next few months, the parents felt that this is again not no longer in his best interest to continue being like this. And therefore, given that the Supreme Court had allowed the family to approach the court again in case they needed any further action, we again filed an application saying requesting for the establishment again of a primary medical board. The request was not for the withdrawal itself, but to simply follow the procedure under the common cause judgment. And so our arguments were also along the lines of first, that artificial nutrition and hydration is a part of life sustaining medical treatment and that it falls squarely under the common cause judgment. The second is that we request the establishment of a primary medical board which will look into the idea, which will look into the medical condition of Harish and also conduct its separate decision making on whether it is in his best interest to continue as such. And then also we sort of brought to the court's notice that the 2023 guidelines have still not been operationalized in most of the states. And that is why we were forced to approach the court to request for the establishment of these boards. So that was our initial sort of application. It took some time, but then in 2025, of course, we had several hearings. There were extensive legal arguments presented from both sides. From the beginning, there was sort of a consensus that, of course, the priority is the best interest of Harish. And it is not about whether there is a right side or a wrong side in that sense. So I think it was not adversarial in any aspect. It was more about reaching a consensus on what the standard is and how we can assist Harish. So yeah, that was sort of the journey before, of course, the court then came out with its judgment.
Okay, it's truly a watershed moment. Advocate Shivika, could you tell us about what was the central government's stance for the first at the start before the Supreme Court in this case, and from the start, how did you balance the state's two duties?
So, since the very beginning, in fact, when the case came to the Supreme Court, the SLP was dismissed, of course, allowing them the right to come back. Then an MA was filed, a modification application asking for certain, so they were asking for financial assistance, they were asking for health assistance. And from the very beginning, the union government has, of course, had a non-adversarial stand. We were interacting with our team, of course, led by the learned Additional Solicitor General. We've continuously been in touch with the hospitals, with the doctors to find out who in fact we can get on board so that his care can be taken in the most appropriate and the most effective and efficient manner. So that round of litigation happened. Then, of course, they filed another application before the court. They came forward and they said that the condition is not getting better, and this clinically assisted nutrition and hydration, uh, it is in fact a part of the medical treatment. So then the common cause guidelines and the common cause judgment should apply to them. So in fact, I remember in my first rounds of discussions with the Additional Solicitor General, we used to have these discussions, and there was a dilemma of, of course, there is life, and but then there is dignity. Indian jurisprudence with respect to euthanasia is only defined by judgments. There is no legislation per se. Though, in fact, today, of course, the watershed judgment that was, they have urged the government to come forward with, a legislation. But otherwise, it is purely defined by the judicial contours, by what guidelines and what directions have come through the judicial pronouncements. So, interpreting all of that, keeping in mind that we cannot, cross or do something which is against the law, but at the same time keeping the principles of right to live with dignity in mind, we moved forward. And of course, like I mentioned, it was completely non-adversarial. um, we've had several interactions with the family. Even the bench had an interaction with the family. And in fact, the Additional Solicitor General visited the house of the parents. met Harish Rana, saw the condition that he was in, spent some time with the family, spent some time with the siblings. He has one brother, one sister. Sister is married. We understood their point. It is not easy, to take such a decision to come to court and say that we want to withdraw the life that is, somebody's son, somebody's brother. But then we had an interaction over video call also with the family, and keeping in mind the contours of the common cause judgment, the common cause guidelines, um, we had presented our arguments and submissions, and now of course the court has given the decision that it has today.
Okay, yeah, I'll come to the vacuum, that statutory vacuum that there is a little later. But before that, Rituparna, this is about ultimately about dignity. So, from a constitutional perspective, how does the right to die with dignity under Article 21 apply in a case like this? Please explain for our viewers.
So I would say, of course, as was pointed out by Shivika, it is of course derived from Article 21, right to life with dignity. I mean, right to life, and then of course it was associated that a life continuing in indignity is not a life worth living. And I think courts over the years have tried to deal with this discussion, albeit I would say in a more ad hoc manner, or perhaps not as comprehensive as has now been discussed by the Supreme Court. But even in 2011, when Aruna Shanbag's case was ongoing, even then the court was very cognizant of the fact that, and even before that, in the Jian Kaur case, like which was again in the early 2000s, there has been a general consensus that you cannot separate life and the continuation of life with the quality of that life itself, and that dignity is inseverable from uh, the continuation of the biological functions themselves. So a step further was taken in the common cause judgment when it was sort of elaborated on that what does how can you include a right to die with dignity under right to life, and it was sort of agreed upon that dignity um, follows even after biological neurological death as well, and a part of life includes that if whenever it comes to an end, the person is not in a state of indignity, and that if if this person is already on medical treatment, then it is withheld or withdrawn only if it is in the best interest of the person. So it was in the common cause judgment when it sort of actively, they started discussing the concept of withdrawal of life sustaining treatment. And I mean, just as a disclaimer and as a sort of guidance and also highlighting the code, um, there is now a distinction between euthanasia and withdrawal or withholding of life sustaining treatment, where now it has been clarified, which has also been said by medical professionals for a long time, is that there is no such delineation between active and passive per se. It's an oxymoron, and that euthanasia has always meant an intentional act. And therefore, active euthanasia and euthanasia are actually synonymous. And instead, what we should now be referring to this is the withdrawal of life support or withdrawal of life sustaining treatment. And we really appreciate that the Supreme Court has highlighted this very clearly, and it sort of has resolved the confusion that persisted in the common cause judgment. But in addition to that, then when of course the guidelines were framed in 2018 and then later revised in 2023, the idea is that while we want to recognize this right, we understand that end of life in general is an extremely sensitive and extremely um, personal and intimate state, and it involves not only the person's own agency, autonomy, dignity, but also the persons who are taking care of them, the persons who are close to them, like family or otherwise, like chosen family as well. So then the discussion was that, okay, how do we ensure that there is a system which not only respects an individual's right to die with dignity, but also ensures that sufficient safeguards are there, so that it is always the person who is at the center of this decision making, even if other people are involved. Of course, what then happened was that when these guidelines were initially made, they were inaccessible to the public, mainly because of how many stakeholders were involved. There was a collector, there was a judicial magistrate of first class, the requirement of drafting and executing an advanced medical directive was pretty tedious, and which is why it was then revised in 2023. Now, the gap that sort of remained is that not all of these cases result in prolonged admission in a hospital. And this is where Harish's case sort of came into the picture, is that his condition did not require him to be in a hospital for the whole time. He was, of course, taken care uh, very well and very dedicatedly by his parents and his siblings. So, in such circumstances, and given that this is a case of permanent vegetative state, and this is again an artificial nutrition and hydration case where there were already debates on whether it's a part of life sustaining treatment or not, it made sense for the Supreme Court to come in and provide that clarity that yes, artificial nutrition and hydration is medical treatment, it is life sustaining, it is not just basic care. The second thing they said is that in order to sort of understand when this right to die with dignity is sort of exercisable, when especially for people who cannot make decisions on their own, which means persons who are in a permanent vegetative state, or other stages where they do not have decision making capacity. For these people, who all are involved, what standards are being utilized to ensure that it's a patient centric shared decision making on their best interest. And which is why you see the Supreme Court in this judgment go into elaborate detail on the standard of best interest, what should be adopted, which is a very welcome addition actually to the jurisprudence on best interest in healthcare. It was sorely needed, and it is wonderful that the court has been sensitive and responsible in sort of elaborating on not only the standards but the whole pipeline of the procedure. Who gets to be involved where do you take shared decision making? Um, so yeah, that was sort of the development of the right to die with dignity and how it sort of culminated in this present case.
Thank you. Thank you so much for explaining it that well. Coming to a very important question, Shivika, could you tell us, since the court had also asked the central government to explore alternative solutions for providing adequate care, uh, how did it go around this? How did you guys go around the alternative solutions part? Could you please elucidate us?
The alternate solution part happened when they had filed an application after the SLP was dismissed, where we got in touch with the CMO, the Chief Medical Officer, Ghaziabad, the Uttar Pradesh hospitals, who could actually go there, take care of the patient, provide in-house treatment, provide financial assistance, all of that, whatever assistance would then be required from the central government, any kind of reimbursement, anything that again we had of course um, uh, clarified and said that we would be willing to make and take. However, the main subject of dispute that arose in the last few months was in fact that they were not okay with even seeing somebody, because I know, because I've had personal interactions, of course. Our counsels from the petitioner side have also had interactions with the family, but talking to them really gives you another perspective. Alternate care is only possible when there is some treatment, and the treatment is making a difference. In this situation, the treatment was futile. Anything that was being given to him, any kind of treatment, any kind of care, there were bed sores. We in fact, the mother told us that the bed sores had to be cut out personally by them. It was a very ghastly situation to be in. And in fact, when the secondary medical board report came, we went through the entire report. We in fact compared it with the medical report of in Aruna Schonberg's case, which is also there in the judgment. And that in Aruna Shanbag's case, at least she was reacting, somewhat reacting. In this case, when there was a threat, is somebody, they do different variations and different kinds of tests on the patient. Some threat perception, no reaction, no awareness, nothing. So living in that kind of condition, that is what compelled us to prepare our arguments in a manner where we can guide the court. Guiding would probably be a better way, because no, even the court was a little skeptical. The kind of, it's a huge decision, taking somebody's life. Guide the court in the best possible manner, keeping in view the judgments and the contours that we are supposed to be within, and then move forward. So the central government stand was always, to ensure that the best care, the best treatment, and if not the best treatment, then the best possible outcome should be there for the family and for the patient.
Okay. Coming to the last question, which is actually for both of you, uh, do you now think that India now finally needs a specific legislation on end of life decisions instead of, like, relying mainly on Supreme Court guidelines? The court, in its judgment, has also very comprehensively mentioned that the prolonged absence of legislation on end of life care has compelled the court time and again to step in and fill the vacuum out of constitutional necessity rather than institutional choice. So, do you now think that India is ready, or there are questions being asked about enforceability of the guidelines as well? So, starting with you, Shivika, what do you think?
um, even the steps that were given in the judgment, if they are to be taken and a proper legislation is to come, of course it's going to be the betterment for the of the country. But even the judgment that was given today, they have really tightened the timelines. So for example, if a primary medical board is formed, they are supposed to give their decision and report in 48 hours. Similarly, the same is to be followed by the secondary medical board. Now that the court has given certain guidelines or a skeleton, it'll be probably somewhat a smoother transition, and the government will be considering, because of course they have kept it pending. The matter is going to be taken up again after 4 weeks as a follow up, and after a month. So I'm sure that some good outcome will come out of it.
Okay, and what about you, Rituparna? Please tell us.
Yeah, I think like as Vidhi and even on a personal level, we do believe that a law would really be beneficial, mainly because healthcare in India, while there are several laws sort of regulating the whole area, we are yet to sort of adopt the practice of really looking at the system as a whole, and sort of figuring out where we want to talk about patient rights, where we want to talk about like regulatory aspects. And ideally it is the parliament or it is the state legislature that is most equipped, mainly because not only are they the representatives of the people, but they are also more equipped to have more representative consultations to consider a wide range of factors. For instance, while the Supreme Court guidelines have been there, some state governments have tried to supplement it, to make it more implementable. For example, Karnataka has issued an order saying that the Board of Medical Experts that is formed under the Transplantation of Human Organs and Tissues Act, like those doctors can also now be part of the secondary medical board. And this is to ensure that doctors can be mobilized faster because these decisions can happen at any point of time throughout the day. Additionally, it is critical, I would say, for India to consider thinking deliberately about decision making capacity as a concept and as something, an element that permeates across all healthcare decisions. End of life care is one of it. While, of course, advanced medical directives now cover cases of terminal illness, persons in permanent vegetative states, and the like, as has been quoted by the Supreme Court. You also have the concept of advanced directives under the Mental Health Care Act. Um, so clearly, there is some legislative intent, there is some judicial intent to recognize these documentations. But a law is what will sort of integrate everything and figure out that okay, what are the whole area of options that a person has to express their preferences, at what point, but what decision making capacity level do they get to take these decisions. If there's a conflict among several family members or nominated representatives, who gets to sort of prevail in those, like how does the doctors sort of resolve any conflict. Doctors have regularly talked about apprehensions of being liable, which of course courts have repeatedly tried to assure them that withdrawing life support in best interest is legal, is valid. But a law can really sort of spell that out better. So I would say that a law would be beneficial in not only corroborating the Supreme Court's guidelines, like consultations can also help us understand whether this model is feasible in the first place again. But you can also go back to the first principles of decision making capacity, dignity, and like what is the regulatory measures you want to keep, what are the responsibilities for hospitals, for doctors, um, who gets to store advanced medical directives, are there any overlaps with the DPDP Act for privacy. These are all things which parliament or the legislatures are best equipped to address. So I would say that yes, a law is beneficial and it is necessary, and the Supreme Court has also urged the parliament to consider this. So we look forward to further deliberations on this.
Thank you so much. Thank you so much, both of you, for joining me today. With that, I come to the end of the interview, and I know both of you are really busy have really busy schedules, and being a weekday, thank you so much for joining us. For our viewers, this is Ruchi Bhattar reporting for The Print. Thank you so much.